Thank you. This case management conference is in the matter of case number CFI 0202023 before His Excellency Justice Nasser al-Nasser. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Nassir H. Bajamal Limited. Lead counsel is Mr. Amir Bajamal, and the defendants are both litigants in person. Thank you, Your Excellency.
Thank you, Lina. We can start with the claimant.
Good afternoon, Your Excellency. This is a case management conference. We shouldn't be taking a lot of your time this afternoon. I would like to give Your Excellency an update about the parties' agreement. So we do have an agreement on the case management order that's fully agreed, and the draft was submitted to court. And we have failed to achieve an agreement on the case memorandum due to differences in the descriptions of the facts. And we've also failed to reach an agreement on the list of issues. So before you will find two different versions of the documents. So with regards to the case memorandum, the claimant's version is filed under Part C of the bundle at page 57, and then the list of issues is filed under the same it's at page starting 57, and then we have the case management order, which was agreed, filed under E of the bundle.
Mm-hmm. But where is the other parties' list of issues and memorandum, case memorandum?
They communicated it to the court by email, as they did not upload it to the bundle. And so perhaps we're not sure if the registry placed them before Your Excellency.
May I speak, Your Excellency?
Yes, you can.
So we have uploaded our case memorandum separately, and as well as sent an email to the claimant, as well as the DIFC court, the e-registry of the DIFC court.
Mm-hmm. You did not upload it on CMS?
So it was uploaded on the portal itself as a case under the case management bundle. So we created a new section, and through that we had uploaded, and thereafter the links were also received by us.
This is the only issue, that the list of issues and the case memorandum are different, yeah? Have not been agreed to.
That's right. In the case memorandum, mainly the definitions, which do not relate to the original tri-party agreement, as well as the list of issues, we had a difference. The only common ground in the case memorandum we found was we both agree that there is a tri-party contract, and the terms of the tri-party contract will normally prevail.
Mm-hmm. But the case management order is agreed on, yeah?
That's right.
Just a minute, I'm trying to find the the email you sent the courts. Let's start by the case memorandum. What are the differences?
With regards to the case memorandum, the differences are mainly about the description of the facts giving rise to the case. From our perspective, the defendant is attempting to insert argumentative statements into the facts rather than keeping them as neutral as possible, as to be expected in such a document. So there was a bit of a misconception about the nature of the document, and that led to the inability to agree.
The case memorandum should be an explanation to the facts of the claim, neutrally, without arguing the case, because the arguments are on the particulars of claim and the defense.
Correct. That's what we have done in our version. But during the discussions, Mr. Khan insisted on inserting certain statements which we found to be argumentative, and therefore we were not able to agree.
Your Excellency, we have not inserted any argumentative statements, whereas we have just said that the definitions in the case memorandum do not match with the original contract tri-party agreement between the claimant and the defendant. And we have just listed about 6 or 7 issues which are related to the case. So there are no argumentative statements. If I would you like me to share my screen to show you the case memorandum right now? Okay. So if you all can see my screen, this is our case memorandum. This is the introduction, so which we of course agree that there's a tri-party agreement in place for the EPMS software and associated services. So on the contract, there are very clearly two parts of the two parts in the agreement. One is the provision, the license to use of a ready-made EPMS software, and the second one is 2 additional software to be customized and developed. So there itself, there is a definition issue because the claimant is, mixing both the software as one. And after mixing both the software as one, they're saying that, the defendant's responsibility encompasses installation and training of the software, which is the first one. And the second one is the customization of software, which is detailed. So here itself, in the services itself, there is a, it's misleading, and that's the reason why we mentioned to the claimant that if the definitions are incorrect, then the entire nature of the claim, the particulars of the claim, the reply to the defendant, everything becomes absolutely irrelevant and misleading. So this was the first point, and this is where we have described the case. The first defendant asserts that EPMS software was supplied in accordance with the industry standard and was demonstrated to the claimant before the purchase. This was our description. Procedural history, we completely agree with the claimant. There is no dispute on that. And the common ground we have is, while the parties acknowledge the agreement's existence and binding nature, So tri-party agreement is completely acknowledged, no problem. Discrepancies still remain regarding the EPMS software's performance and delivery. So these were the uh, this was the nature of the claim anyway. Our list of issues, first of all, is that the defendants adheres to all the contractual obligations demonstrated by the delivery of EPMS software and responsive service. So we have completed all our obligations. The claimant's extensive use of the software versus the claim of non-performance. This is our issue number 2. So they have used the software, they've used our intellectual property, and uh, and after 2 years, approximately 2 years of usage, the claims of non-performance is our second issue. The timeliness of the claim under the principles of lashes and its implications. This is number 3. The number 4 is the absence of contractual provision for damages concerning the claimant's decision to engage on an alternative software supplier. So there is no coverage of any of the clause in the original agreement about damages or engaging an alternative supplier, especially when all the obligations were completely met. And the impact of there is a previous SCT judgment. So we have just mentioned if there is any impact dismissing a similar claim based on the same agreement previously. Uh, and and the issue number 6 is the lack of direct payment evidence to the first defendant and the strategic implications of the claimant's selective legal approach. Clarification of the refund clause, especially in the context of the developed software versus the EPMS. So there are two separate softwares. EPMS was meant for our scope of work, which is clearly mentioned in the tri-party agreement, is the scope of work is only to install and train. And we have the sign of certificates from the customer. So the obligation of EPMS is completely met. So there is no question of any ambiguity. And the second issue is if they have procured an alternative software, it is their prerogative. So that was our point number 7. And lastly, the claimant's engagement and payment for an annual maintenance contract post-delivery, indicating recognition of software's functionality and utility. So once the software is live, after 6 months of usage, they have paid for the annual maintenance, which basically renews. It's like a renewal of the contract. So that means any party will only renew the contract once it's successfully working fine. So these were our issues from our side.
Thank you, Mr. Khan. And if the parties fail to agree on the list of issues and the memorandum, I think each one will have his own case memorandum and list of issues. Yeah,
That's right, Your
That's
Excellency.
acceptable to us, Your Excellency.
but the case management order is agreed on.
Correct. So this is a case where both parties believe that it will be beneficial for the court to appoint a court-appointed expert.
We don't.
Due to the,
I'm sorry, but we don't appoint experts. The court does not appoint experts.
well, this is the because under the rules, it is permissible for the court under Part 31 to appoint an expert, and therefore the parties' agreement come from that part in the RDC rules.
31.
Yes, it's part 31 of the RDC rules. So the court has the power to appoint a court-appointed expert.
But in practice, we never appoint experts. The experts are appointed by the parties.
But if this is, I mean, the power does exist under the rules, and if there's a rejection of this request, then we would request for a reasoned decision so we can then take instructions and come back to the court with a position. I understand that it is not commonly practiced, that this discretion is not usual, this power is not usually exercised by the court. However, it is in the rules, and our
Can you refer
instruction
me
is
to
that,
the rule exactly?
it is rule 31.29.
Okay, it states that the court may appoint one or more independent experts to report to it on specific issues designated by the courts. But I'm telling you now that the court will not appoint an expert.
Okay, so I understand that. So this is a rejection of the application made by the parties.
However,
So
however, the parties are given the opportunity to appoint their own experts. Either they agree on an expert, or each party shall have his own expert. And then the reports will be filed to the courts. In the draft case management order, it specifies how and when the experts shall finalize their report, meet, and submit their final report. In the template.
may I propose something, Your Excellency? That so if it is acceptable to the court that the parties agree on one expert, then this can be filed as evidence, because the value of the claim does not justify having the parties appoint each an expert on each side. So perhaps because already Mr. Khan accepted that, so maybe the court should give us an opportunity to agree on one expert, and then the report of that expert can be filed as evidence, and then the court will have the benefit of that.
Does the other party agree on that?
So, Your Excellency, I mean, we are okay to appoint our own expert, and so can the claimant appoint their own expert. However, we would like the access of the live system, so which is under claimant's control. So they will have to give us access to the live system in order for us to be able to show that everything is working fine to the expert.
I'm not quite sure, what do you mean by live system?
The live system means the production environment, so where the software is installed. So we would like to get an access to that. And
Well,
the server
procedure,
of
we
the
can.
Sorry.
I'm not quite sure whether that is possible or not. I think this will fall under the procedures to be agreed for the experts' work. So we're happy to discuss anything at that stage. So, Mr. Khan, I take it that your position is that you do not want to appoint a joint expert. You would like to continue with having separate experts.
Yeah, the law gives us the provision to appoint our own expert, and I think so can the claimant. But again, the very important point related to this is the access to the servers, which is in claimant's control. Because the expert would like to see the software, they would like to see the functions of the software that is installed on the claimant side. Because without seeing the software, I'm sure expert cannot compile and complete their reports.
I'm not able to confirm that at the moment because I have to take instructions, but we will discuss that in due course. Your Excellency, I think that it is clear now that we have to revise the case management order in light of today's instructions. So perhaps we will need to revise part of it and then refile it with the court. I don't anticipate any disagreements between the parties because it will just be about dates, and the rest is going to be as laid out in the RDC rules.
Okay, then once it's finalized, kindly send it to the court so we can so I can review it and approve and seal and issue the case management order.
Thank you.
Anything else from the parties?
Not from the claimant.
There is one point from our side, Your Excellency. I'd like to request before you today to address a matter of significant importance to the defense in line with the provisions outlined in the rules of DIFC Court, particularly referring to the rule 26.51. This rule allows for introduction of additional claims, including counterclaims within the same legal proceedings. As the defendant in this case, after a thorough review of the claims brought against me and careful consideration of the circumstances surrounding this dispute, I have identified ground for counterclaim that directly relates to the original claim made by claimant. The basis of this counterclaim arises from the time and efforts that are spent by myself as the CEO and the COO of the company in preparation for this case, somewhat missed business opportunities directly attributing to the claimant's action on the ongoing legal proceedings. So I kindly request the Honorable Court to accept our request in terms of filing the counterclaim at this stage. I acknowledge that my initial defense did not include this counterclaim. However, the developments and revelations that have emerged during the preparation and ongoing management of this case have highlighted the necessity and relevance of introducing this counterclaim at this juncture. I believe it is only relevant but only essential for ensuring comprehensive resolution for all disputes between the parties involved.
Then in this case, I think lots of dates will be changed. Yeah.
So yeah, in conclusion, Your Honor, I respectfully submit this request to your consideration of the counterclaim within
the counterclaim. Yes.
That's right. I would like to add a counterclaim.
Your Excellency, we strongly object to allowing such a request because at every junction from the beginning of this case, the defendant was always late in their filings, were always not compliant with the RDC rules. We've had a period of almost 3 months where the court was supposed to deal with an application for a late filing of the defense itself. And this was in circumstances where there was a consent order signed between the defendant and the claimant, in which the claimant was allowed time. So in the beginning, the defendant failed to file a defense at all. And later on, the defendant reached out to the claimant and said that that was as a result of the email going to the wrong inbox. And as a result of that, we have given Mr. Khan the courtesy of an extension, and we signed a consent order to that effect, specifying the date for filing the defense. And then on that date, again, the defendant failed to file a defense, and they filed it late. Thereafter, they filed an application to the court to give them a retrospective extension to the date. That application sat for more than 3 months without decision, and then we recently had a decision on that application allowing the defense. So for the defendant to come this late in the procedure to request for yet another change to the process, it is extremely detrimental and prejudicial to the claimant and will cause further delays in addition to the earlier delays.
However, the rule 26.51 clearly states that during the case management conference, the defendant can add a counterclaim, and we are just abiding by the rules. The previous delays were a different a series of events because there was a second defendant involved at that time, and their legal team was driving this case. But unfortunately, after the series of events, the legal team of second defendant only absolved themselves and did not file anything on our behalf. That's the reason for those delays. So those matters are completely different to this. So I'm only referring to the rule which says in 26.51.
I have the rules in front of me, and Rule 26.49 states the following: wherever possible, any party who intends to file an additional claim should do so before the hearing of the case management conference dealing with the main claim.
And what is
So
26. And can you also read what 26.51 says?
No, it says where permission to make an additional claim is required, it should be sought at the case management conference. So these are rules concerning adding a claim. So it should be first outlined before the case management order. It should be presented before the case management order. This is what the rules envisage. And then the order itself can be issued during the case management. So not the application itself. The application itself cannot be made during the case management conference. It has to be made before, and then the court may decide, because ideally a party should give the opposing party the opportunity to respond and give the court the opportunity to consider. If the application is filed during the CMC, then that reduces everyone's ability to consider the application.
Well, it's not the application that we're filing. We're just requesting for us in order to be able to file an application. That can be then.
It doesn't. The terminology doesn't matter. You are seeking an order for permission to insert a counterclaim. Whether it's a request or an application, it doesn't matter.
I think the defendant has the right to request for an additional claim, which is a counterclaim, at the case management conference. Yes, before the CMC, at the level of the pleadings, a permission is not required to file a counterclaim. But since we have reached to this level, I think there should be a permission from the courts for additional claims, which is a counterclaim. And this will also affect then the date of the claimant to file its defense as well. Yeah?
Thank you, Your Excellency. I appreciate that.
And then I think there should be a second CMC. Yes?
Are these your instructions, Your Excellency?
Yes, I'll allow the defendant to file a counter claim, and then I'll allow. However, the defendant shall provide a timetable on when the counterclaim will be filed and when each dates to the response. But my concern is, why did the defendant wait until today to make such requests when they could have made an application previously for additional claims?
In fact, Your Excellency, we filed an application uh, 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 for another purpose, that was for the dismissal of the case, because we thought that uh, uh, there was no merits to this case to proceed further. The reason being because only the definitions itself are not related to the original agreement, and the scope of agreement clearly says that our software is only installation and training. Whereas even in the case memorandum, the claimant is always mentioning its installation, training, customization, development, and few other things. So there itself is a major discrepancy, and that's the reason why we had filed an application for the dismissal of the case. But unfortunately, that did not go in our favor, and we did not anticipate that it would consume so much time and efforts. So earlier we thought there were good merits of the case, from the defendant's point of view. But later on, I think, as it proved out to be lengthy and time consuming, there's a lot of time and efforts that are involved by me as the CEO. We are a small business in Dubai, and our employees' time is basically important for us, and that's what is being allocated for this case. This is one of the reasons why we could not even get a legal representation due to financial constraints.
And you are aware that if you were unsuccessful in your claim and counterclaim, you will bear the costs, yeah, of the other party, the legal costs.
That's right, Your Excellency.
You're aware of that, yeah?
Yes,
As a litigant in person.
that's right, Your Excellency.
On that note, Your Excellency, I would also like to point out that in light of the counterclaim being allowed to be brought in, the claimant will be filing an application for security for costs on account of the counterclaim elements, because the defendant has an outstanding costs order from the immediate judgment stage that has not been paid, and the claimant is concerned about the defendant's ability to satisfy costs at any later stage. So that also will need to be factored into the timetable.
The claimant has the right to file an application for security of cost.
Thank you.
So in terms of the counterclaim, I will give you until 28th of March as a deadline to file your counterclaim. If by 28th of March you have not filed your counterclaim, this case management order will stand and will remain as it is. The only part which will be discussed is the expert's part, which will be altered, and that's it. Yeah.
And for the claimant's response, would Your Excellency give us directions on time as well, or the normal time would apply under the rules?
The normal time would apply under the rules. Yeah, just the deadline for the counterclaim to be filed in order not to delay the matter further than this.
Thank you.
Yeah, and the claimant, as I mentioned, has the right to file its application for security of costs.
We will do that in due course.
Anything else?
And Mr. Bajamal, by when can we get a confirmation that access to the live system will be provided, so that we can also start working on the expert subject?
This is not something that we're able to discuss at this stage. as per the timetable, there will be timelines for the parties, experts to contact each other and the parties to arrange that. So when we reach that stage, we will inform you and we can answer any questions you would like us to answer.
Yes, exactly.
Okay, thank you.
I don't think it's the right time now before appointing an expert to ask for access to the software. Yeah.
Right, Your Excellency.
Anyways, anything else from the parties?
Nothing further from our side.
That's all, Your Excellency, from our side as well.
So the deadline is 28 March, yeah? To file
Yes,
a complaint.
yes, I've noted. Thank you.
Thank you, both parties.
Thank you.
Thank you then.